For more on this, we're joined via Zoom by legal analyst Sinawo Makangela as we unpack the Parliamentary Committee probing advocate Busisiwe Mkhwebane's fitness to hold office. A very good afternoon to you, Sinawo. Thank you for your time with us here on the SABC.
Thank you, Leslie. Thank you for having me, and good afternoon to the viewers as well.
Let's try to make sense of the dynamics unfolding at this point. Any surprises on the lack of response by the suspended public protector? In the same breath, what do you think the impact this is going to have on the work before the committee, perhaps before they edge closer to that 28th of July deadline?
I think perhaps this could have been avoided if by March, when there was an indication by the Office of the Public Protector, South Africa, that they are running out of funds and they will not be proceeding to pay for the suspended public protector. I believe that Parliament probably would have avoided the situation that it finds itself in. Remember, the suspended public protector is still in the witness box. She's under oath. She's testifying orally. And all that process, before it could ensue, there were directives that were agreed to by the parties. For any changes, all the parties would be invited and an input would be sought from them. And then everyone would be told that this is how we're going to proceed in this process. So if you get the views from the committee, from the PP, there is an indication that that route now has been changed. The fact that now she was requested to make her submissions in a written form is not part of the directives of the very same committee. So it may open another gap to the challenge. It's an obvious challenge. If the committee is going to establish its own directives, establish its own processes, and then it undermines the very same processes that it has adopted, that would lead to an unintended consequence. That is but the first one. Then the second one, an indication again that she made was that she has been given 10 days to answer to those questions. Now she's dealing with those reports, CX report, 3D report, and all those things, you know. So her contention is that that is not sufficient for her. 10 days is too little. But that is besides the point. The worst would be if really it's what came from Parliament to say, no, your new legal representative, your new attorneys don't have to read the records. They can just they can act as post box, take the records, give it to your lead counsel. I don't think that's fairness. Remember, if you talk about fair process, you mean everyone must have proper representation. No one can be represented if does not even understand what kind of testimony has been led. As I say, the ball has been dropped by allowing the process to come to a halt at the end of March.
Sinawo, thank you for that context. Perhaps you can help us then understand the impasse over her legal representation and what this ultimately means. Will the committee meet the 28th of July deadline at this point? And you cited a number of issues by the suspended public protector, including legal fees, including the unrealistic timelines. There was also another factor of the recusal application in relation to the chairperson of the committee. Help us also explore and understand what this means for the committee's work at large.
Well, the committee has got its own timetable. The committee is planning to finalize everything by the end of the month so that it can submit its report to the National Assembly. The committee, by the look of things, will proceed according to its own timelines. It did say it is having some deadlines to ensure that by the time the term of the suspended public protector comes to an end in October, everything must have been finalized by the National Assembly. We are just dealing with the processes now. Now, the issue of the legal representation, seemingly, it remains a contentious issue as well, the issues of the budgeting. As I say, if you speak about the proceedings that started, I think, around July sometime last year, those records would have been voluminous. So if you talk about the fairness, everyone must be given enough time, you know. If there is consideration to the public interest, the interest of the public protector as well, taxpayers' money, but without compromising the interest of justice in the process. I mean, a clear-cut result is the one that we all know, that the case that is in the public domain of Senzo Meyiwa. You know, at some point, new lawyers had to come in But for fairness, because the interest must be balanced, there is a victim, that is the family of Senzo Mewa, that has been looking for justice. Then the accused persons, some of them have been in jail, but the court had to allow a process where those new lawyers had to have enough time to go through the records because they were not party to those proceedings. Look again now, a new judge is appointed. The likelihood is that, or chances, high chances are 99% chances are that the process will start afresh because you talk about the fairness to the process so
Yes.
that a fair and just equitable decision is taken at the end of the day than to rush the process. We know that the victim's family want justice. So this is not different from this one. As South Africans, everyone is waiting it out to ensure that this process is concluded. We want to know what's going to happen next. But the process must not be compromised.
Yeah.
Remember, we all know that this is the first of its kind in the country. But where there are those obvious gaps, perhaps some of them can be avoided than to push each other. Whether there is a recusal application that is coming, well, every party has a right where it feels there is a conflict along the way to bring that kind of an application. Then the chairperson will make a determination. If the chairperson refuses, then the courts are there to make their own determination as well.
Well, speaking of just and equitable processes, perhaps also this in the interest of the public as well as the use of taxpayers' monies at large, the search for the new public protector also gets underway. How does this process perhaps influence the Chapter 9 institution at large going forward for the country, perhaps as we edge closer to elections and beyond?
In fact, there are lessons. Remember, this is the first of its own kind. This is the first process in our constitutional democracy where the Chapter 9 Chapter 9 institution head is being removed. So this is how the process is unfolding. Obviously, other lawmakers, should this kind of a situation exist in future, we'll pick up some lessons and try to take really some stock and do probably better than what happened in this process.